My name is Aaron Sadler. I'm the spokesman for the Attorney General's office, and I'm glad all of you are here today. Just a reminder, if you're tweeting, please use the FOIA Forum hashtag, so hashtag FOIA Forum. And also, we are live streaming, so if you want to get that out on social media to your friends who couldn't be here today, the live stream link is tinyurl.com/2014 FOIA Forum. And I'll say that again, tinyurl.com/2014 FOIA Forum. Our next presenter is Assistant Attorney General Ryan Owsley. I've been with the Attorney General's office about 4 years, and it seems like we've had about 70 or 80 FOIA presentations that Ryan has put on, and I learned something new in every one of them. Ryan's a dynamic speaker. He knows FOIA inside and out. Anytime I get a media question about FOIA, I immediately go to Ryan because I know he's going to answer it. He's going to answer it correctly. Ryan received his Bachelor of Arts degree in Philosophy and Ethics from Ouachita Baptist with honors. He received his law degree from the Bowen School of Law here in Little Rock with honors and was editor of the school's law review. He was a clerk for Supreme Court Associate Justice Annabelle Clinton Ember, and he briefly worked in private practice before coming to the Opinions Department of the Attorney General's office, where he is now. Ryan has conducted, like I said, probably no exaggeration, about 70, whether it be for FOIA roadshows, speaking to county officials, city officials, state government agencies, seminars, to lay people, to government agencies, even to representatives of foreign governments. He is also a co-editor of the most recent edition of the Arkansas FOIA Handbook, which, if you didn't get a copy, you can pick up a copy of the newest FOIA Handbook back at the back on our table. And with that, I'll turn it over to Ryan for his presentation on FOIA.
Normally I would not use a microphone in our setting here, but so the recording can pick me up while I'll be doing that. Well, hopefully somebody can turn it on. If it's not, then I'll lay it aside. I'll hold on to a couple more minutes and then we'll scrap it. Are you picking it up? Okay, good. So here's my objective. Now, a lot of you folks, I've seen some of you before. I know some of you guys. You've come to FOIA roadshows before. You have prior knowledge. Some of you may not. So we've got a mixed group. And not everybody's starting at the same place in terms of FOIA. So here's my objective for the next 40 minutes or so, is to just give a framework for thinking about FOI issues, and also to give a shared vocabulary for everybody in here. So as we progress through the rest of our FOIA forum, everybody can have a similar set of terms and definitions and tests. Now, you've heard people talk about these road shows that are given periodically. These are 2 hours instead of 40 minutes of what I'm about to do now. We'll often do 2 hours worth of explanations. So there's a lot of stuff I'm not going to cover, okay? So I'm just saying all that by way of saying this is going to be really streamlined. The primary thing I want everybody to take away are those two things: the framework, which I'm just about to explain, and also this sort of common vocabulary, the shared understanding. Now, before we get into the nuts and bolts, we want to get is the basic principles, which actually come into play sometimes when you get into some of these gray areas. And the first is the main point. The main point of the FOIA is to keep the electorate informed of what's going on in government, informed of what's going on with their public funds when those are being routed to private entities as well. That's the main idea. And that main idea gets spun out into two principles. And the Arkansas Supreme Court has said this in that Lehman versus McCord case in the late 60s. It gets spun out in two ways. First, all of the provisions in favor of openness, we construe those broadly. All of the provisions in favor of non-disclosure, we construe those narrowly. So, said another way, when we're on the fence, is this exempt, is this not exempt, we construe it narrowly. We err in favor of disclosure. Okay, that's the way that this general principle gets put into practice when we start to get into the nuts and bolts of the exemptions. Here is this three-step approach. I said I was going to give you a framework for thinking about FOIA-related questions. The first, and it's a three-step approach. The first is you're going to ask yourself, is the entity that we're talking about here, is it covered? For example, is the entity whose records I'm trying to obtain subject to the FOIA in the first place? If it's not, the FOIA doesn't apply to them. If you say, yeah, that entity is covered by the FOIA, we go on to the next step, which is the record or the meeting, whichever one we're dealing with, is the record of meeting covered by the FOIA. If you say no, you stop the analysis. You do not continue to go on to exemption. This is important because people very often confuse exemptions and the definitions from meetings and records. So after you answer that second question, yeah, this record we're dealing with, or this meeting that we're considering having or considering attending, maybe you want to attend, yeah, that's subject to the Act. Now we want to know, are there any exceptions that would shield that document from disclosure? Listen, all exemptions are mandatory. There are a couple of exemptions from meetings, but they're permissive. So that means that you can hold those open even if there is an exemption for the meeting. But all the exemptions for records are mandatory. So somebody who's a custodian has to walk the line of saying, look, I can't disclose it if it is exempt. I'm not able just to turn it over. So there they are. That's your 3 steps. Those are the main 3 things that I want you to take away. You're not going to remember a lot of the nuts and bolts of what I'm going to talk about in relation to each of these steps. And by the way, a larger version of this PowerPoint is available on our website if you want to find it there. We're going to spend just real briefly on this first step. Is the entity covered? And we're going to move on to the records and the meetings. Is the entity covered? All government entities are covered. Easy. All government entities are subject to the Act. You're talking about a government entity, we're going to answer yes to this first step. Some private entities are subject to the FOIA. That's a big deal. It's not like that in every state. Some private entities are subject to the FOIA. There is some confusion, I feel like, about this because of a couple of Arkansas Supreme Court cases. But there's no question that some private entities are subject to the FOIA. Which ones? How do you know which ones are subject to the FOIA? Well, there's this test, and it's got some gray areas around the edges, but the core of it, here it is. In order for a private entity, a private corporation, for example, it's a non-profit corporation, fine, it's a for-profit corporation, whatever. In order for that private entity to be subject to the FOIA, 2 things must be the case. First, they must receive public funds, and they must be entwined with government. They must be engaged in activities that entwine them with government. Let me give an example to put some flesh on it. In 2009, our office, the Opinions Department, were asked about a scenario where a school district contracted with a private company to bus kids from home to school and back, and also from school to field trips and back. And we're asked the question, is this entity, the private organization, subject to the FOIA? What do you think we said? Yes. That's right. We said yes because they got those public funds as part of the contract. Also, they were engaged, they were intertwined with government. They were doing something that the school district had an obligation to do, number one, and would have been doing apart from its relationship with that private corporation. They were publicly funded and intertwined with government. Let me say one more thing before we move on past this topic. In one of the seminars that I gave, a person sort of sheepishly raised her hand and she said, I run a nonprofit and I want to know if we're subject to the FOIA. And I said, well, you're the expert. Now you've got the test. Let's run the test. Do you receive public funds? And she said, yes, we do. We get donations all the time. And that was a joke, by the way. Most people laugh when I throw that one out there. We get donations all the time. The whole idea of public funds is tax dollars being routed from the government to the organization, not a person pulling into the checkbook and sending it out. Okay, so that's what we mean by public funds. Not just funds from the general public. Tax dollars being routed to those organizations. All right. So that's it for private, or for whether the entity is covered. Now we're going to presume, as we continue on, that the entity is covered. What we're going to do now is go on to step 2. Remember, is the record or meeting covered? So what we're going to do to make it a little easier to follow is we're going to talk about records first. Is the record covered? And then we're going to go to talk about some records exemptions. And then we'll go back up later and talk about meetings and some meetings exemptions. All the while assuming that we've answered our first question affirmatively. Yes, the entity is covered. Now, in order to know, there's the whole ballgame with this second step about public records is identifying a public record. What is it? And there's a lot of confusion here, not so much as there used to be, but some folks are surprised at what a public record actually is. There's a big, huge definition of it. It's like a 60 or 70 word sentence. And then you'll find it there in your little blue book. which reproduces the entirety of the FOIA. Got some trouble here. So, what is a public record? We're going to distill down that giant hunk of a paragraph, 60 to 70 words, into 3 elements. A public record is a writing, a recording, audio or video, electronic information that is kept, that's number 2, and number 3, that constitutes the performance or lack of performance of an official function. That's what a public record is. Is the police recording on a police cruiser, the camera on the dashboard, is that a public record? Yeah, it is. The reason it is a public record is because it meets all of those elements. It is electronic information, in this case specifically a video. We'll assume that it's kept in the course of business. And sure, it reflects the performance of that police officer's official functions. Some folks are surprised about this. Let me ask this way. If I send a grocery list using my AG email account to my wife, and it's titled Kroger List, and on it it says, don't forget to pick up bread and eggs and milk. Get the little gummy snacks the kids like too. Is that a public record? You send on my AG email account, on my AG computer. We always get some noddings and some shakings right about now, which we're getting a little bit.
Wouldn't it be because it's stored on publicly funded government equipment?
Okay, good. So he says, well, wouldn't it be a public record since it's stored on publicly funded government equipment? That's nowhere in the definition. Whether it was transmitted over publicly funded equipment, it's nowhere in the definition of a public record. That grocery list is a grocery list. It's not part of the performance of my official functions as an opinions writer at the Attorney General's office. Let's flip the other side of it. If it mattered whether you were using public or private means to transmit a message, then you could just use your Gmail account to get around all the FOIA rules. Because you're using a private means of transmitting things that would otherwise, let's assume they would otherwise be public. And the Supreme Court has said that doesn't work that way. You can't use, for example, a Gmail account to transmit an otherwise public record to try and shield it from that. So, we've got the grocery list, we've got the police cruiser. Let me give another example. If you've got two public officials and they communicate with each other about public business via their privately paid for cell phones. They text each other. Is that a public record?
Yes.
How do you know? You run the test. Exactly right. That's right. You're sufficiently trained. We're getting ready to move off this topic. It's electronic information. We'll assume that it's kept, and it reflects the performance of official functions. You say, what about the grocery list? What about the grocery list? Okay, very good. She says, well, what about the grocery list? Doesn't it show the lack of performance? And the short answer is no, because, I'm going to give, it's a little delicate to get into because it's going to take a second to talk about. But there's like a 500-page treatise written by these two law professors on the FOIA, and then all of our opinions over the last 30 years. There's unanimity among those sources that grocery list is not a public record. Also, there's 2007 Arkansas Supreme Court case, which essentially says the same thing. Now let me explain why. Because we've got to give some meaning to lack of performance of official functions. If everything that a public employee does on public time is either the official functions or not. Agreed? Right. That's right. So, if everything that's not official function counts as a public record, then everything is a public record. Are you with me on that? And if that's what the legislature intended, then instead of writing a 70-word sentence, they would have just said everything created is a public record. Right here.
Going back to the text on private cell phones between two individuals, what is the meaning of are kept? Kept by whom?
Good. Okay. These are good questions. I wasn't anticipating this, so we're going to zoom past some other things, but let's stick on this for a second. What about kept? I keep saying we'll assume that it's kept. The law says writing, recording, electronic information, record all this stuff. that used to say that is required by law to be kept. And so what would happen is people would make FOIA requests for information that did exist. The custodian would hold it up and say, here it is, but no law requires us to keep it. So it's not a public record, and therefore you're not entitled to it. So they amended the FOIA to say that it is required by law to be kept or is otherwise kept. So if it exists, and you're talking about paper records, if it exists. Now when you get into electronic information, we've got difficulty in terms of, well, when does it not exist? Because in a certain sense, you can delete and double delete, and there's sort of fragments still exist. Maybe that's a discussion for later in the program when we talk about electronic information in the FOIA, and we'll come back to that. That's a very good question. We need to move forward after we've covered this definition about public records. We've locked down our definition of a public record: a writing, recording, electronic information, audio, video that is kept, that constitutes the performance or lack of performance of an official functions. I locked in my definition. How do I apply it to a given document? Well, we run the test like we just said, and our general rule is we disclose it unless it's exempt. And that's it. We've covered what is, in the definition of a public record, what is, I think, one of the most frequently misunderstood, and frankly, a little bit, there's some gray areas, difficult part in identifying even what is a public record. People always want to jump to the exemptions. But we have to start with step 2. Is the record covered or not? If it's not, if the record itself is not covered, we don't continue with the analysis. Now, that concludes step 2. Is the record covered? We're going to assume that we said yes to that. If we said no, the record is not covered, we do not continue with the exemptions. That's important because very often people will not pose the questions that remember I said I want to give you a common framework and a common vocabulary. Very often people will pose FOIA questions like this: is that record disclosable? Can you get that record under the FOIA? And you see how, and that's fine, I say that sometimes too, but we have to remember that that actually is 2 separate questions. Is that a public record, and then are there any exemptions to it? Because the answer to the question, can you get that record under the FOIA, it could be no, either because it's not a public record, or no because it is a public record but it's exempted. Step 3, are there any exemptions? Don't freak out about this next slide. Here are where all the exemptions can be found. There are lots of places, locations, where information and records are exempted from the FOIA, but only that green box, there's a list, about 19 exemptions that are contained in the FOIA itself, and we don't have time to cover most of those. What we're going to do instead is cover what I consider the kind of workhorse exceptions under the FOIA. The workhorse because they get used most often, and unfortunately they're very often misunderstood. So they get played up a lot, and people can unintentionally mangle them. And that's because the test for the release of these records is opposite. I once trained some custodians on how to handle these records, and once I finished training them on these records, someone kind of sheepishly raised her hand, and she looked really distraught. And I said, yeah, what's your question? And she said, so you mean if the test is this, then you release it? And I said, yeah, that's exactly right. She goes, I always thought it was the exact opposite. So she was saying, in other words, she's telling this room full of people, I have been releasing what I shouldn't and keeping what I shouldn't. Because she misunderstood the tests. And it's not entirely her fault because the language is a little bit squirrely on some of these. So we'll try to isolate why it is that people can get these messed up a little bit. What we'll do here is we'll talk about personnel records and evals, and each slide will be essentially identical. I have the same 3 parts: the definition, what I'm calling a stance, which is my attempt to kind of isolate why it is that people can mess up the test, get it exactly opposite, and then the rule for disclosure for that particular document. After we've already identified, we're dealing with a public record, and we're talking about these 2 workhorse exceptions, personnel records and employee evals, we have to do 2 things. There's a definition. Certain records that are public records are personnel records. Well, what's that? What is a personnel record? Well, it's virtually any record that pertains to an individual employee that is not an eval, a job performance or employee evaluation document. I just say eval. Virtually any record that pertains to an individual employee that's not an eval, and we'll get some examples of that in just a second. If you identify this document that I'm holding is a personnel record, or the document that I'm seeking, I think it's a personnel record. The stance for the custodian that they need to adopt is this: The document will be disclosed unless. The document will be disclosed unless doing so constitutes a clearly unwarranted invasion of personal privacy. Not an invasion of personal privacy, an unwarranted invasion of personal privacy, and that must be clear. A clearly unwarranted invasion of personal privacy. That's a pretty high bar, which means most personal records go out. And there's this case called Young versus Rice, an Arkansas Supreme Court case, where they tried to give some flesh to this rule and how you actually work it out into practice. And if there are questions about that later, maybe we can go into that. So there's kind of a two-part test that you use to determine whether it's clearly unwarranted. But once you've identified, I've got my document, it's a personnel record, my stance is, if I'm the custodian, I'm going to disclose it unless it meets this test. One second, let me get to the next slide and then I'll take questions. Next slide, employee evals. An evaluation has a clearer definition. It is any document that's created by or at the behest of the employer to evaluate the employee. Any document created by or at the behest of the employer to evaluate the employee. If I receive a letter of commendation from my supervisor, is that an employee evaluation? Give me a shake or a nod. Evals can be good, right? Thank you. Evals don't always have to be bad. Sometimes public employees do it right, and they get commended. But that is an eval, okay? Because it's prepared by my employer to evaluate me. Now, letter of reprimand, is that an eval? Yes, right, of course. And other documents that are generated in the investigation leading to some disciplinary action against the employee. If we've got our definition, this is an eval. We say, okay, here's an eval, it's a letter of commendation. This is an eval, it's a letter of reprimand. What will our stance be, if you're the custodian, with respect to that document's release? The stance will be, it must be withheld unless. When we're dealing with personnel records, and you identify, yeah, I'm dealing with a personnel record, our stance is the opposite. It must be disclosed unless it meets the test. When we're dealing with evals, our stance is it must be withheld unless it meets this test. And it's a four-part conjunctive test. You've got to have all four parts. Unless what? We're going to withhold it unless what? Unless the employee was suspended or fired. Stop. That letter of commendation, is that letter of commendation disclosable under the FOIA? No. Why? Because you weren't fired for it. You were commended for it. Does a letter of reprimand get disclosed? No. You were reprimanded. You were not fired or suspended for it. There's some exceptions that come later, but let's just stick with the main rule. Person must be suspended or fired. That must be final, administratively. Those records that are being sought must be relevant to or form the basis for that final suspension or termination, and there must be a compelling public interest in the disclosure of that record. This tilts, obviously, when you look at these two slides together, personnel records on the one hand and evals on the other, it tilts in favor of the release of evals and against the release of, in favor of the release of personnel records and against the release of evals. Everybody see that? And the reason it tilts like that is because of the stance. You must, on the personnel records, disclose it unless, and on evals, you must withhold it unless it meets the standard. What this means, why would you tilt that way? Why would you tilt? Every state has some version of what most states call a deliberative process exception. And you'll see it again in a minute once we get to meetings. We'll see the same type of exception, deliberative process exception, pop up in meetings, in the meetings context. Every state has something like this. The idea here is that you shield the process, that in certain circumstances, we want to shield the process that led to the final conclusion. So we'll shield maybe the discussion, or we'll shield the investigation, but if there's some final outcome, depending on what the outcome is, we'll disclose it. So remember I told you about that woman who said, so you mean if they weren't suspended or fired and they can't disclose it? And I said, that's exactly right. You have to be, at a minimum, suspended or fired in order to disclose an eval. And she thought it was the opposite. Because she thought the easy stuff, the good stuff, like the commendation or the reprimand, it wasn't that bad, so it should get disclosed. But it's the opposite. It's the really bad stuff that needs to be disclosed. Everybody see that? Because whatever they did, they had to get suspended or fired for it. And that was final. Maybe they went through an administrative grievance process, and that was upheld, and so on. Okay? You run that test. And so the really bad stuff, we think that needs to come out, and people need to have access to that. But the other stuff, apart from that, the idea behind the deliberative process exception is there's a concern among all the states, and they work this out, the nuts and bolts, a little differently depending on the state and depending on the issue. The idea is, look, if everything in the process is open here, then maybe the employer is not going to be as candid when evaluating their employee. So if it's something short of being suspended or fired, we are going to let that stuff be shielded from disclosure because we want full candor from the supervisor to the employee. And there's a concern that if you shine a light on that always, all the time, then people are not going to say what really they think. That's the idea behind it, behind the deliberative process exception. We'll see it again in a minute when we get to executive sessions in the meetings context. It's the exact same idea. Yes, ma'am. Did everybody hear that question? I'm going to just kind of sum up the question. If a person gets a letter of reprimand and later is fired for the reasons in the letter of reprimand, that's one of the exceptions that we won't really get into. It depends on the facts. Because sometimes a person is reprimanded and that's it. And the next time they're reprimanded again and they're told, and if you do it again, you're going to be fired. And then we begin to hook those things in. They become a kind of a totality here, and they're all relevant to this final suspension determination. Yes, sir. What about redactions? Can you make, yes, is a short answer, but not on employee evaluations. There's no basis to redact an employee evaluation. Either the whole document goes out or none of it goes out. When we're dealing with redactions, which we'll talk about in a minute. We've got a couple of slides on redactions. You're typically talking about personnel records. One other question, and then we have to move on. Yes, sir. That never happens here. So that's a pure hypothetical. I'm sure that's right. I mean, the reality is that the statute doesn't say what counts as a compelling public interest. And so this is where, and there really aren't a lot of court cases on what counts as a public interest. So the short answer is there's not a lot of information on that. But of course, I mentioned the treatise earlier, and we've got some opinions in our office that try to begin to give some idea of what that could mean, but it can't be an exhaustive description because the statute doesn't give one, and neither have the courts. But one idea to keep in mind is a public controversy associated with something. That can be perhaps a compelling public interest, but that's a little bit tricky too because sometimes you don't have a public controversy until the information gets out. And then, you see what I mean? So it's a little bit difficult, and we just have to, at this stage in the game, we just have to be, it's difficult, and we can't nail it down with all precision. One more question. You're fervently waving your hand. Very good. Yeah, she said, can the subject, and put it this way, can the employee get his or her own records? And the answer is yes. There's a separate subsection, it's 2519-105C2, which says employees can get their own records. So anything, personnel record, employee evaluation record that's otherwise closed, the employee can get their own stuff. Okay? Sure, you can do whatever on with it. So for example, like the letter of commendation, I can get that and disclose that if I want to. You can do it, it's your record. Now, enforcement on the FOIA. There's civil suits and there's the Class C misdemeanor. And this has been an uptick. When we first started doing these roadshows, there weren't that many prosecutions. In the last 5 years, especially in the last maybe 3 to 4 years, there's been a significant uptick in both investigations from prosecutors and also actual prosecutions. And you know, you can probably speculate about what some of the reasons are for that. Maybe kind of the downturn in the economy, people are not able to or don't want to foot the bill for their own lawsuit, their own civil lawsuit. But there they are. Those are the only two remedies under the FOIA. There's no administrative remedy. It's all judicial. We're going to talk a little bit, real briefly, maybe 5 to 8 minutes, on how a person makes a FOIA request and how a custodian, must evaluate a FOIA request, and then we'll get on to meetings. And there are going to be some things I typically cover at this part of the talk that we're going to postpone to later, maybe when we talk about electronic information and stuff like that later in our forum. How long does the custodian have to respond? Well, the statute gives two timelines depending on whether the record is in active use or storage. Active use or storage. If it is not in active use or storage, it must be disclosed immediately. If it is in active use or storage, you have 3 business days to disclose it. The trouble is, you're about to ask me, what does that mean, active use? There you go. I'm right here with you. Active use. What does it mean? The statute doesn't say, and courts haven't said either. It's hard to imagine things that are, it's just going to be a fact question. I mean, some people, the way they maintain their desk, they have so much stuff on their desk that they don't use for a month at a time. The fact that it's on their desk may not be very telling. For other folks, the fact that it's on their desk tells you a lot, right? It's just a fact question, and there's not a lot that we can say about that, really. That's how long you have to respond. Redactions. We asked a question about redactions. I always say, wield the Sharpie. Now, that graphic is not important at all. I'm just showing you what your document needs to look like. Your document needs to look like that if you're the custodian. If you've made a FOIA request and you receive a document and there's redactions, here's the idea. I say wield the Sharpie because you must be able to see that something has been redacted. No whiteout. If there's whiteout, you're running the risk of tampering with a public record because you're concealing the fact, you may be concealing the fact, concealing information on that document. Wield the Sharpie. Now, the reality is sometimes we've got wimpy Sharpies today. Wimpy Sharpies. You go to redact something and it makes the ink glow. Like, it doesn't actually do the work, and you've got to make a copy. And you do the copy, and that really knocks it out. Can you charge for that copy? No. You cannot charge for that copy because the custodian must always bear the cost of redactions. And you had to use that, you had to make the copy because you had a substandard Sharpie. If you made Sharpies, they're probably too toxic to actually use. But if they, right, you wouldn't have to make the copy in the first place. But you do need to make those redactions. Why? Because exemptions are mandatory. Wield the Sharpie. Here's some commonly exempted information that you can find on public records. Marital status, info on dependents. There's just no public interest in knowing the names of a public employee's children, for example. There's no public interest in that. That gets redacted. There's no public interest in knowing whether so-and-so is married. That gets redacted. Their tax information, their withholdings, that stuff gets redacted. Yes, sir. Well, we don't have to get to that question because in the last session, everybody hear that? What about cell phone numbers? 2519 105C or B13 exempts all personal cell phones numbers. So that's just a lockdown exemption. You don't run any balancing tests. You don't. Personal cell phone numbers of non-elected employees, municipal, school, state, so on. Okay. Well, personal meaning that it's I mean, like your personal address, you got your work address. You know, who personally pays for it? That can go into whether it is personal or not. The statute doesn't tell you. Well, what do we mean by personal? But this is going to be a fact question. Some people walk around with a BlackBerry on this hip and an iPhone on this hip, and we all know the BlackBerry is the work and the iPhone is the personal, right? So whatever the personal phone actually is, that's the one you don't disclose. And you just got to ask your people: is this your personal phone or not? And now the reality is some people use one phone, and that gets into a more dicey situation that we can talk about later when we talk about electronic information. Information is typically open. Public employees, if you're here, your salary goes out. It's already out probably if you're a state employee. People object to this, and you know the 300 plus FOIA opinions that General McDaniel mentioned earlier, I've written a large portion of those, and sometimes people will come to our office and object to the release of their name. One guy said, I hereby forbid anyone from releasing my name under the FOIA without my express written permission. And we said, your name goes out. This information goes out. Charging for copies. Charging for copies. And we got about 2 minutes on this, and then we'll talk about meetings. Charging for copies. Before we get to the charging, there's one little threshold thing. If you're the custodian and the person asked to inspect the records, can you charge them for the copies? Say no, no. Because the FOIA, I once had a law professor in civil procedure say, the plaintiff is the master of the suit. They can choose where to file it. They can choose the types of claims to bring. In the FOIA context, the requester is the master of the request. The FOIA requester can say, I'd like copies, for which they can be charged, an amount we're about to talk about, or I'd like to inspect. And if they ask to inspect, you can't charge them for copies. Here's the thing, though. I hear this a lot. Custodians will say, well, you've asked to inspect, here are the records. And there's all kinds of information in there that cannot be disclosed. Because why? Exemptions are mandatory. So the reality is, from the custodian's perspective, preparing the documents for copying or to be disclosed in response to a copy request or to be inspected, from the custodian's perspective, it's basically the same protocol. But from the charging perspective, it's different. You can't charge the people, even for the cost of making the redactions, you know, the bad Sharpie that I talked about earlier. You can't charge for that. The statute says the custodian must bear the cost for the redactions. If they ask for copies, what can you charge? The statute says the actual cost of reproduction. And people want to say, well, what does that mean? Well, it just says actual costs. The reality is, if you go to this government agency, they may have a lousy lease agreement with so-and-so, and their actual costs really are 35 cents per page. And you go over here, and they've got a good lease agreement, and they're with their copy people, and maybe it's 2 cents a page. What I tell government officials and public employees, don't sit around with each other and say, what do you think? What does a library charge? Do they charge maybe 8 cents? What do you think? A quarter? What do you think? 10 cents? And so what I say to the way I train custodians is, you need to, whatever figure you come up with there, you need to be able to foresee yourself standing in front of a judge and answering the question, how'd you come up with that figure? And if you're able to say, well, we got our lease agreements, we got our per page copy costs, and we factored in this, and then we divided that, and here's our number. You'll be fine. But you got to realize, if you're from the requester's perspective, the costs can vary. If you're from the custodian's perspective, try to nail down a cost, right? It does not include the employee time associated with making all those reactions. Custodians do not like this. It does not include the employee time associated with making the redactions. There is a whole other part of the FOIA, 2519-109, which is confusingly titled Special Requests for Electronic Information. And that title alone, I'm confident, has confused people endlessly about what that provision is about. It's not about requests for electronic information. That should better be titled, and we can talk about it later, Special Agreements to Produce Electronic Information. And we'll talk more about that later. Only in that limited context does charging for employee time come up. In the vast majority of cases, you are not allowed to charge for employee time associated with responding to that request. Now, the one bone that the FOIA throws toward custodians who are having to field abusive requests, and there are abusive requests, there's probably a small percentage, who knows really what the percentage is, but they are out there. And the one bone that the FOIA throws to requests or custodians is that $25 in advance. And when I first started studying and presenting on the FOIA, I thought that meant that the custodian, let's say that the charge for the copy, the actual cost of reproduction, I do all these copies, it's going to be $30. I thought that what it meant was you can charge $25 ahead of time, right, the earnest money, and then they show up later and pick up and then pay their $5, the remainder. Not what the text says. You can charge the full $30 before you engage in all this. Sometimes these can get really exorbitant, these fees. Can get really $1,000, $3,000, whatever. As long as that's the actual cost, the custodian is going to be fine. But you have to tell them that ahead of time. And also, if you're going to charge, you got to itemize. Okay? Also, if you're going to charge, you got to itemize. And we've got to move on to talking about meetings, the whole other part of the act. Now, the reason why we spend about 2/3 to 3/4 on records is because it's far more technical than meetings. There are a lot more definitions, a lot more tests, a lot more balancing this, and a lot more rules about that. We spent a good deal of time on the definition of a public record before we ever continued on. Well, friends, there's no definition of a public meeting. Well, here it is. We'll show it to you. Here it is, right? This is the only text of the statute that I reproduced in the PowerPoint. There it is, because you got to see it. 2519-106A, this is going to define for you a public meeting. A public meeting is all meetings, formal, informal, special, or regular, of the governing bodies of all municipalities, counties, agencies, and so on. Those things shall be public meetings. In other words, all meetings are public meetings. But what's a meeting? When you use the word in the definition, we're no better off, usually. Right? So what it tells you is, while there is here's the upshot, while there is a technical definition of a public record, there is not a technical definition of a public meeting. There's not a technical. And so what people invariably do is say, well, it must be at least 2 people. It must be at least 3 people. They want a technical definition, and they want to tie it to the numbers. But the Supreme Court has said that won't work. There's a case out of Fort Smith, a 2004 case, where there's what we call a polling scenario, where no 2 members of the governing body ever actually met. It was the city attorney who was pulling members of the governing body into a kind of an anteroom and saying, here's what we're going to talk about, and here's what we're going to vote on this issue. Are you up or down? They say, I'm up. And then we go to the next person. Here's what we're going to vote about. Are you up or down? And by the way, they're up. And it went down the whole list. And they thought they were complying with the act because they invented a numbers rule. And you can sort of say, well, that's reasonable. It takes at least 2 people to have a meeting, right? And they never, and the Supreme Court said, that's a meeting. You guys you've had a meeting there. So what kind of upshot can we give there? And we'll just say this. What we tell folks is, if you are talking about business, public business that's likely to come before your body, then you need to stop. That's probably a meeting. If the conversation at the coffee shop runs into public business incidentally and goes away quickly, probably not a public meeting. It's hazy, the statute is hazy, and the court, and especially just either last year or the year prior, refused to clarify it further. So we just have to live with the haziness for a while. Once you identify, this one always freaks people out too, but take a second, let it sink in. This is actually, this is the universe of meetings. All meetings are either open or closed. Even a closed meeting is a public meeting. You hear that? Even a closed meeting is a public meeting, and there are protocols that you have to follow when you have your closed meeting. And there are only 3 types of closed meetings that you can have. You see them there. Whether your meeting is regular or special, this is not just an exercise in cool grass. Maybe it's not even so cool, but it's not even an exercise in that. There are different rules that apply to whether you have an open or closed meeting. There are different rules that apply whether you have a regular or special meeting. And the rules go to always, here's the upshot, we have a hard time identifying what is a public meeting, but we do the best we can. And why do we care about that? Because there are 2 rules that apply. Remember, in the records context, we identify we have a public record. What's the rule? Disclose unless it's exempt. In the public meetings context, we identify as best we can whether we have a public meeting, and there are 2 rules that apply. Notice and attendance. Notice and attendance. And the notice rules are pretty technical. And I'll just flash them up here on the screen. We'll talk about emails later. You can see more about this, again, on our website, where I have this up there. It's pretty technical. Anytime people ask me about notice, I always go back to the statute because it's kind of technical. The bottom line here is nobody gets notice of a regular or a special meeting unless they ask for it. As a minimum threshold, you have to ask for it. And then there's some rules about how, in advance of the meeting, the notice must be given. We don't have a whole lot of time to get into it. That's the first so what after you identify it's a public meeting. We're dealing with a public meeting, so what? Notice rules apply, and also attendance rules apply. You got to hold the meeting open. Typically, it's just attendance. You don't have to let somebody stand up and state their piece. At least under the FOIA, you don't. There's another statute, there it is, 1414, that says for counties, you got to let them state their piece. But that's not a FOIA rule. That's outside the FOIA. It's a different statute. Whether you have a closed meeting or an open meeting, the voting must be conducted in public. This is very important. The voting must be conducted in public. And this goes back to the very first slide that we had. The whole purpose of the FOIA is so that people can see what their representatives are doing. And if the voting is shielded, a significant part of the purpose of the FOIA is frustrated. You've done the best you can to identify whether you have a public meeting. You say, yeah, we've got a public meeting. We've identified our notice rules, our attendance rules. Are there any exceptions? Remember, there's those 3 exceptions: licensing exams, water security, that's a post 9/11 thing, and personnel matters. And we'll just talk about personnel matters. Most most executive sessions, that's just a closed-door meeting, are conducted on the basis of a personnel matters executive session, which can only be to consider one person for one of those things. The text says only for the hiring, firing, appointing, promoting, demoting, so on. Before you go into executive session, you've got to stand out in front of the door and say, we're getting ready to retire to executive session for personnel matters executive session. And maybe you got to go a little further too and say, to consider the hiring of someone. You don't have to name the person. Consider the disciplining of someone. But you have to state the reason for the executive session before you go into it. And there is a procedure. All your notice rules still apply. And we had to gloss over the notice rules earlier, but they still apply. You've got to announce your purpose. Who may attend? This is the main thing about executive sessions. Not just anybody can go into an executive session. There they are, the governing body itself, top administrator, immediate supervisor, employee person being interviewed for a top administrative position. It's actually a little more technical than that, but for our purposes, those are the folks that can attend. Not the lawyer. The lawyer cannot go into executive session. Nobody else can show up either. Now, when you're finished with your executive session, you must come out in public, and if you arrive, the text says, any motion considered or arrived at, not sure what that means, must be voted on in public. So at a minimum, if you have taken some official action, that must be voted on in public in order for it to be valid and binding. And that's it. Here's some additional places for more information. You've got your little blue book. That's referenced there. The big treatise, you can find that online, or you can find how to order that online. You can't find it online. And then we've got our website, too. You want to add at the end of that gov/opinions, and you can search all of our FOIA opinions. In fact, we've got like a little, in our new website, we've got a way that you can search all and only the FOIA opinions for additional information. Thank you.